Can an implied contract alter at-will termination rights? Imagine working at a company 4 years and feeling confident that your job is secure. Suddenly, you hear something that makes you wonder if your employment rights have changed. That's where implied contracts come into play. They can sometimes influence how and when an employer can end your job. In most states in the United States, employment is considered at will. This means either the employer or employee can end the relationship at any time, for almost any reason, or even no reason at all. It sounds simple, but things get more complicated when actions or words create an expectation that the job isn't so easily terminated. An implied contract is formed when an employer's conduct, statements, or policies suggest that employment will only be ended for cause or under specific conditions. For example, if an employer promises job security in an employee handbook or makes verbal assurances about long-term employment, those can be seen as creating an implied contract. When courts find an implied contract, the employment relationship shifts away from pure at-will. The employer then must follow the terms of that implied agreement, which often means providing a valid reason or following certain procedures before ending employment. This can include showing just cause or giving warnings, depending on what the implied contract suggests. Courts look at the whole situation to decide if an implied contract exists. They consider employer statements, written policies, employee handbooks, and what the employer has actually done over time. Even verbal promises can be part of this. If enough evidence points to an understanding that employment is not at will, the court may uphold that as an implied contract. This can be a big deal for employees. If an implied contract is recognized, an employee might challenge a termination if it violates the implied terms. Employers need to be careful about what they say or do, as these actions could unintentionally create legal obligations. It's important to remember that how courts view implied contracts varies from state to state. Some states are more willing to enforce these implied promises, while others stick closely to the at-will rule. So, to answer the question directly, yes, an implied contract can change the default at-will rights. It can limit an employer's ability to fire someone without cause by establishing that employment must follow certain conditions or procedures. This makes understanding the context of employment relationships and employer communications essential in labor and employment law.